Yeah. What is this would be the remainder of the motion to direct the verdict and those who deny, is or no. And I'll get back to the look at another government. All right, good deal. whole bunch of exhibits. Yeah, no, I mean, and my understanding is that with the technical, one of the instructions I read, the way that you obviously talked about being revenue and that they entitled considerations of and that I think that information or you're not doing that, but then put it to consideration.
We had someone lined up for dramatic reasons. Yeah.
I think it was what I'm looking to see is how businesses are lining up and what happens. Sometimes there's similar to last night's directed verdict. Not before that scene, but we did it. Pragmatic scheduling very much towards the end, so I can understand all the lines. But again, it may be that depending on the email, and if that's the email, we'll take what do you think?
Good morning, please be seated. We've got a couple devices here. Thank you. All right, so good morning, and I can say that having had a little bailiff coverage yesterday, I can tell you guys are in a more boisterous mood when Miss Deanda is serving as bailiff. So I hope you had a good evening. Were you able to adhere to the court's instructions? All right, as always, thank you for that. With that, I think we can get right to it.
Yes, thank you, Your Honor. We have some documents to move into the record. The first document is Plaintiff's Exhibit 03485. This is an interrogatory. The interrogatory seeks countermetrics Meta evaluated when considering whether or not to implement youth safety tools. Meta's response states that the following are examples of these metrics: monthly active users, daily active users, time spent, sessions, impressions, and viewpoint view.
Okay, that is admitted, unless you've got a couple other.
Yeah, I've got 4 interrogatories. I can go through them all.
Yeah, please go through.
Okay. The second is Plaintiff Exhibit 03491. This interrogatory seeks information about Meta's integrity classifiers, and Meta's response includes descriptions of those classifiers. The interrogatory response was discussed during the testimony of Dr. Arvind Narayanan. Next interrogatory is Plaintiff's Exhibit 03509. This interrogatory seeks engagement metrics Meta tracks for certain public statements made by Meta and its employees, which Meta provided on a global basis. The next exhibit is Plaintiff's Exhibit 03550. This interrogatory seeks information about Meta's implementation of end-to-end encryption. Meta's response includes descriptions of when it implemented end-to-end encryption on its platforms and the scope of messages or other content that Meta encrypts. And so those are the interrogatory responses that we seek to move in, Your Honor.
All right, and ladies and gentlemen, at the start of trial, you may still remember this, I had read you an instruction about interrogatories. And the instruction was that interrogatories are written questions asked by one party to another before trial and answered under oath. The questions and answers may be read at trial as evidence. The answers read to you are entitled to the same consideration as any other testimony. I read that to you now because I'm admitting these interrogatory responses, but you'll see there's a lot to them sometimes in terms of numbers and other things that make them very difficult to read. So I'm not going to read them to you or have counsel do that. But nevertheless, they'll be in your evidence to be considered, and they're entitled to the same consideration as any other testimony, okay? All right, thank you.
Thank you. And Your Honor, we have some exhibits to move in. With respect to the McNamara deposition, which was played March 2nd to March 3rd, the plaintiffs move in Plaintiff's Exhibit 00709, which was Exhibit 26 to that deposition. Plaintiff's Exhibit 00841, which was Exhibit 4 to that deposition. Plaintiff's Exhibit 02389, which was Exhibit 19 to that deposition. Plaintiff's Exhibit 03203, which was Exhibit 15 to that deposition. Plaintiff's Exhibit 03391, which was Exhibit 30 to that deposition. Plaintiff's Exhibit 03581, which was Exhibit 5 to that deposition. Plaintiff's Exhibit 03582, which was Exhibit 8 to that deposition. And Plaintiff's Exhibit 04129, which was Exhibit 9 to that deposition.
All right, and those are admitted.
Thank you, Your Honor. Okay. Plaintiffs, there is a set of documents the parties have stipulated to be admitted, and I'll read those, the exhibit numbers to the record. They are Defendant's Exhibit 0405, Defendant's Exhibit 1183, Defendant's Exhibit 2809, Defendant's Exhibit 2810, Plaintiff's Exhibit 00223, Plaintiff's Exhibit 00248, Plaintiff's Exhibit 00362, Plaintiff's Exhibit 00472, Plaintiff's Exhibit 00489, Plaintiff's Exhibit 00599, Plaintiff's Exhibit 00609, Plaintiff's Exhibit 00611, Plaintiff's Exhibit 00992, Plaintiff's Exhibit 01350, Plaintiff's Exhibit 01487, Plaintiff's Exhibit 01730, Plaintiff's Exhibit 02173, Plaintiff's Exhibit 02783, Plaintiff's Exhibit 02991, Plaintiff's Exhibit 03114, Plaintiff's Exhibit 03276, Plaintiff's Exhibit 03685, and Plaintiff's Exhibit 03779.
All right, and those are admitted as well.
Thank you, Your Honor. With respect to the Messeri deposition, plaintiffs move in the following exhibits. Plaintiff's Exhibit 00037, which was Exhibit 14 to that deposition. Plaintiff's Exhibit 419, which was Exhibit 8.1 to the deposition. Plaintiff's Exhibit 420, which was Exhibit 8.2 to the deposition. Plaintiff's Exhibit 462, which was Exhibit 10 to the deposition. Plaintiff's Exhibit 479, which was Exhibit 45 to the deposition. Plaintiff's Exhibit 656, which was Exhibit 44 to the deposition. Plaintiff's Exhibit 669, Exhibit 43 to the deposition. Plaintiff's Exhibit 942, which was Exhibit 12 to the deposition. Plaintiff's Exhibit 956, which was Exhibit 58 to the deposition. Plaintiff's Exhibit 1121, which was Exhibit 24 to the deposition. Plaintiff's Exhibit 1123, which was Exhibit 29 to the deposition. Plaintiff's Exhibit 1218, which was Exhibit 8 to the deposition. Plaintiff's Exhibit 1517, which was Exhibit 17.1 to the deposition. Plaintiff's Exhibit 1518, which was Exhibit 17.2 to the deposition. Plaintiff's Exhibit 1681, which is Exhibit 36 to the deposition. Plaintiff's Exhibit 1767, which was Exhibit 31 to the deposition. Plaintiff's Exhibit 2961, which was Exhibit 1 to the deposition. Plaintiff's Exhibit 2962, which was Exhibit 108 to the deposition. Plaintiff's Exhibit 2964, which is Exhibit 13 to the deposition. Plaintiff's Exhibit 2965, which was Exhibit 21 to the deposition. Plaintiff's Exhibit 2966, which was Exhibit 28 to the deposition. Plaintiff's Exhibit 2974, Exhibit 7 to the deposition. Plaintiff's Exhibit 3296, which was Exhibit 16 to the deposition. Plaintiff's Exhibit 3585, which was Exhibit 20 to the deposition. Plaintiff's Exhibit 3587, which was Exhibit 46 to the deposition. Plaintiff's Exhibit 4048, which was Exhibit 22 to the deposition. And Plaintiff's Exhibit 4307, which was Exhibit 47 to the deposition.
All right, those are admitted as well.
All right, and finally, Your Honor, with respect to the Zuckerberg deposition, the plaintiffs move in the following exhibits. Plaintiff's Exhibit 62, which was Exhibit 12 to the deposition. Plaintiff's Exhibit 63, which on my list says it's also Exhibit 12 to the deposition. Plaintiff's Exhibit 430, which was one to the deposition. Plaintiff's Exhibit 696, which was Exhibit 26 to the deposition. Plaintiff's Exhibit 865, which was Exhibit 39 to the deposition. Plaintiff's Exhibit 1288, which was Exhibit 23 to the deposition. Plaintiff's Exhibit 1321, which was Exhibit 32 to the deposition. Plaintiff's Exhibit 1494, which was Exhibit 68 to the deposition. Plaintiff's Exhibit 1650, which was Exhibit 5 to the deposition. Plaintiff's 1664, which I have as Exhibit 11 to the deposition. Plaintiffs Exhibit 1855, Exhibit 30. Plaintiffs Exhibit 2925, Exhibit 33. Plaintiffs 3008, Exhibit 20. Plaintiffs Exhibit 3009, Exhibit 21. Plaintiffs Exhibit 3576, I believe was Exhibit 11 to the latter part of the deposition. Plaintiffs Exhibit 4023, which was Exhibit 69 to the deposition. Plaintiffs Exhibit 4298, which was Exhibit 40 to the deposition.
All right, those are admitted as well.
Thank you. And that concludes the reading of the numbers for today, Your Honor.
Well, and ladies and gentlemen, that shows you why I didn't have the courage to have counsel or myself read the interrogatory answers with all of those numbers for you as evidence. But here's the other piece that's important, I think, which is that recitation right there is a result of all the counsel in this room and their staff working very hard after hours to reduce the amount of white noise that I'm playing for you and the like. And so while it's a lengthy recitation, everyone in this room, I think, deserves a lot of credit to do it in such an efficient manner and respect your time. So thank you, everybody in the room, for that.
And thank you, Your Honor, for your assistance in that effort. And Your Honor, with that, and with gratitude to the court and to the jury, the state rests its case.
All right. Thank you, counsel.
Your Honor, can I approach with some documents for you?
Yes, you may.
And sticking here, you can just read out some more numbers for a couple hours, but Meta eagerly begins its defense case with Your Honor's permission by calling Mary Worth.
Certainly.
Good morning.
Water.
Oh,
That's
good.
not a big
And tissues.
deal. Absolutely. I'll swear you under oath.
Okay.
Please raise your right hand. Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. You're under oath. Please be seated.
Good morning, ladies and gentlemen. Welcome to Meta's defense case. Good morning, Ms. Worth.
Good morning.
How are you feeling?
I never knew there could be so much pollen in the world, so I'm not crying. I'm just, all the allergy meds in the world can't contain this. So I apologize if I sneeze through a lot of my testimony.
Please do apologize. I will sympathetically say.
Yes.
My name is Alex Parkinson. I'm an attorney for Meta, and I'm going to be doing your direct exam today. Could you please introduce yourself to the jury?
My name is Mary Catherine Worth.
Okay. Did you prepare some slides to accompany your presentation today?
Yes, I did.
Okay. Your Honor, if we could please publish to the witness DDX 19.1.
Yes.
And Ms. Worth, these are in the binder in front of you as well, the blue
Oh,
one.
this binder right here?
The blue one. We have the slides and a little insert in the front. And if you would,
Oh, you know what? My glasses went missing somewhere.
my glasses are not a popular fashion choice apparently, but I can.
I think they're probably in the
May I approach the witness, Your Honor?
room that we were just in.
I have loaned these glasses to other witnesses.
Great. I think they're going to find mine, but
All right. Did
I
you
had
find-
them. Now I don't have them, but
did you
that's
Find the witness's glasses.
that's kind of
with
typical for me.
permission
So
or approach?
Thank you, Your Honor.
I'm curious for who wore it best between the two of you, but do we?
I'll go
yeah,
check.
those will work. Thank you.
Okay. Ms. Worth, if you have a chance to look at the demonstrative on the screen and maybe in the binder flap, at the very front flap there.
Okay, there's just an introductory page here. There's not a.
That's right.
Yeah.
Do these look like the slides that you prepared?
Yes.
Okay, Your Honor, permission to please publish to the jury.
Yes, you may.
Ms. Worth, did you prepare a slide showing your credentials?
Yes, I did. Although I'm not seeing. Sorry.
No problem.
At what tab is the?
No problem. They're in the front fold here.
There's a tab. There should be a tab number. Those are mine. Thank you.
Trade you
Yes, I really appreciate it.
behind this sheet.
Oh, behind this sheet here. Okay, thanks. All right, I've got it.
Great. If we could please publish DDX 19.2. Ms. Worth, is this the slide that presents the credentials that you prepared for the jury today?
Yeah, it's a very short, just quick overview.
Okay, well, can you give the jury a quick summary of what you do for your work?
Okay, well, so what I've done for my work in the past, what I do now is, I mean, I'm semi-retired. I live on a farm. I split my time between consulting and taking care of too many rescue animals. But I started off as a lawyer back in 1992, and then I eventually ended up working for a number of very large technology companies. In 2000, I went to the internet company Yahoo, where I oversaw all of its international litigation, law enforcement response, and compliance work. Took a break for 2 years after I adopted my daughter, and then went to Adobe, the software company, when they were looking to change their business from being a company where they stuff a disk in a box and ship it out around the world to being like a cloud computing company where photographers around the world can upload all of their photography to your cloud. And at Adobe, I went there to advise them through that transition and to build out from zero all of their trust and safety functions, their anti-CSAM functions, and the like. And during the 11 years I was at Adobe, I was its primary delegate to all anti-CSAM, and by CSAM, I'm sure you've heard the term, but child sexual abuse material. All sort of anti-CSAM coalitions, technology coalition, working with NCMEC, the National Center for Missing and Exploited Children, working with Thorn, a nonprofit that creates technology that helps in a variety of ways in this space, and then also attending the Dallas Crimes Against Children conference, speaking there, things to that effect. So,
Okay, I want to break all of that down. Now, you
Yeah.
used a term at the start of that called trust and safety.
yes.
What do you mean by trust and safety? What is that?
So trust and safety is a term that's been coined more recently. We didn't really have a name for it when I first started working in this space, but it's the function, the function within a company, an internet company, that sets policy for what you can and can't do on the platform, and then develops the infrastructure that helps you enforce those rules, helps people report violations, helps your team that you have inside the company take action against violations that have been reported, everything that fits underneath that rubric, including programs to stop the upload and spread of child sexual abuse material.
Okay. And what is the relationship between trust and safety and anti-CSAM or child sexual abuse material work?
Well, in the broader picture with trust and safety, you're trying to prevent all problem material that you forbid by your policies from being uploaded or shared. CSAM is a subset set of problem data that you're also working to get taken down. Some companies do it only reactively when it's reported to them. Others develop proactive programs to go out and proactively find it themselves using technologies like photo DNA, et cetera.
Okay. I apologize. I want to back up for a moment.
Okay.
You're here as an expert. Can you please tell the jury your educational background?
Okay. Well, I have a bachelor's in history. I have a law degree from Hastings College of the Law. I'm a certified information privacy professional.
Okay.
And I've been working in, 34 years now since I graduated law school. 26 of those working in trust and safety and related functions. So
You mentioned law school. Are you still a licensed attorney today?
yes, I am.
Are you here testifying as a lawyer?
I am not here testifying as a lawyer. I'm here testifying as a subject matter expert in the very practical day-to-day operation of trust and safety programs and anti-CSAM programs.
I think something that folks might want to know is, have you ever represented Meta as a lawyer?
I have not.
Okay. So after graduating from law school, what work did you do initially, right after law school?
Well, it first right after law school, I went to a law firm in Los Angeles called O'Melveny and Myers because I'd gone to law school in San Francisco, but I wanted to do First Amendment and media defense work. And so you had to go to New York or LA, so I went to LA. And I ended up working with a great partner there where my primary client was Fox. It was right when the Fox network had launched. And I represented all of the Fox television stations, et cetera, in media defense cases. I represented them against O.J. Simpson. This is LA in the 90s. I represented them against the Menendez brothers, for God's sake. And eventually I went in-house at Fox to head up all First Amendment and media work for the company for about a year. And then I moved back to Northern California.
Okay. And I think you've talked about this a little bit at the start. But
Can you speak up a little bit? That's another thing is my high range hearing is a little iffy.
The jury knows I'm really soft spoken and I don't get very loud at people, so I'll speak
So you
up.
need to be louder and get closer to your microphone. Just push the microphone closer to you.
Yes, ma'am. Thank you. You talked about this a little bit. So you leave the law firm and what do you do next?
Well, after I leave the law firm and I go to Fox, in-house at Fox for a while, I moved to Northern California and I was a trial lawyer at the law firm McCutcheon Doyle Brown and Anderson. I represented media clients there, but also clients like Stanford University, a variety of different clients. And then after about 3 years, I was talking with somebody from the company Yahoo, and they asked if I would consider becoming the company's, this is very early on in Yahoo's history when it was kind of the biggest internet company in the world. Well, it was the biggest internet company in the world. If I would go to the company and consider overseeing all of its international legal function, predominantly because a lot of the fights that they were having then in the early days of the internet, you could see the internet from everywhere, but there were no clear rules about who had the right to regulate what. So they were being sued in France over Nazi-related content on the US-based website that was constitutionally protected in the US, but illegal overseas in France. And it was really one of the first big fights over who gets to say what on the internet. And they knew they were going to be having more of them. So they asked me to come in and oversee it.
Okay. If we could please look at DDX 19.3. What is this?
Oh, this is embarrassing. That's me, how many years ago? 2002. That's me when I'm working on the Yahoo France case. So an article written about me back in 2002.
Okay.
And this is where, it mentions that what I cover is both litigation and compliance, but.
Okay, if we could please publish DDX 19.4. And Ms. Worth, what is this? I think you've talked about it briefly.
Oh, that's just an excerpt from the article.
Okay. How long did you work at Yahoo?
I was at Yahoo from, I guess, around August 2000 to, well, I went on maternity. I left when I went on maternity leave. So that was June of 2026.
Okay, you said that's when you adopted your daughter, is that?
Yes.
Was your role at Yahoo purely legal?
My role at Yahoo was not purely legal. In fact, and I wasn't really aware that that was going to happen when I took the job. So I kind of landed in what eventually became my real career a little inadvertently. So when I went to Yahoo, I was overseeing international litigation, and they said, and compliance. And I didn't really realize that what they meant by compliance was really everything that you think about as trust and safety now. They didn't call it that back then. So now I find myself responsible for the speech, all the content policies for every Yahoo property outside of the United States, everything that's not America, and responsible for ensuring we enforced appropriately in those countries, all of whom have drastically different content regulations. And then 9/11 happened and we're overwhelmed. I mean, every airline ticket for the planes was bought using Yahoo Travel. We're inundated in search warrants. And next thing I know, I own the international law enforcement response function and had to build that out in response, post 9/11. Yeah, I mean, that's basically the range of what I covered. And then child safety made its way in because when law enforcement comes to you, well, post 9/11, a law was passed called the Patriot Act, where law enforcement, if there was an imminent risk of harm to human life and they needed data now to save that life and couldn't go to court to get a warrant and they could give you proof, the service provider in their discretion could turn over data without a warrant to prevent that imminent risk of harm to human life. And, you know, back in that day, to staff something 24/7, we didn't have people at the property 24/7. We carried pagers. The US compliance team had their pagers, and the international compliance team, which was me and my team, we rotated who had the pager and had to like sleep with the pager in case somebody needed you in the middle of the night. And sometimes that was a child sexual abuse emergency, you know.
I was about to ask, did the work at Yahoo involve anti-child sexual abuse material work?
Not at the outset.
Mhm.
So, so my first real introduction to it was via some of my law enforcement response work, and then a case that came up in, I guess, the end of 2002 that, you know, we had hundreds of search warrants served on the company all in the same day. And what was at the time the biggest child porn bust in US history, announced by then Attorney General John Ashcroft. We had acquired a company called eGroups. And I don't know how many of you remember Yahoo Groups. I used to use it a lot, but we bought eGroups, we turned it into Yahoo Groups, and unbeknownst to us, one of the private sharing groups there was an extraordinarily heinous CSAM sharing group. And so, but back then we didn't have any technologies like photo DNA or anything to proactively search for the materials. So when we got this search warrant, it was news to us. And my team was, you know, the domestic team had to do the heavy lifting on that. But then eventually we started getting international process because there were many international users. And so my team had to bundle up the accounts for law enforcement. And that was really the first time I was exposed to what a serious problem it was. I think in my head at that time, being naive, which I wish I still was, but I'm not. I think I always thought of, you know, back then they called it child pornography. I think I always thought of it as the, oh, she, you know, sexual material, if she might be 16, she could be 18 variety. And I think it was the first time I really realized that there was a big distribution market out there for imagery of prepubescent kids.
Okay. And we're going to get into that and a lot of the tools you mentioned. I want to stay in Yahoo for a moment. And you've alluded to this. Did you work with law enforcement while you were at Yahoo?
Oh, all the time. I mean, so I worked with them on non-CSAM matters whenever we had law enforcement requests come in. I worked with them when we had imminent harm emergencies, where we had to get them data right then or something terrible would happen. And I worked with them. One of my jobs was negotiating with foreign intelligence agencies, so like MI5. I mean, we were the only licensed service provider in China, Beijing Public Security Bureau. It was kind of crazy. So a lot of time working with law enforcement in those regards.
Okay. And actually, I want to pause on one thing you mentioned. You said back then you called it child pornography. We keep hearing this other term, CSAM. Can you just tell the jury what the distinction is and why the evolution in that term?
Well, in the industry, I mean, child pornography was the old term, but pornography, regular pornography, which is legal, right? That's consensual. Nothing about this is consensual. And so there was a real push among those of us that work in the child safety community to agree on terminology, and terminology that made it clear that there was nothing sexual about this. This was abuse.
Yeah.
And so that's how the term came into being.
Thank you for that clarification. Now, you are actually not the first person we've heard from who worked at Yahoo. And I just have to ask, did you ever work with a team at Yahoo called the Paranoids?
I did.
Okay, what was that?
Oh, so the Paranoid team, and I kind of loved this, that, you know, they were called the Paranoids and not the security group, but they were the security team for Yahoo, keeping your network safe, keeping your, you know, connections safe, making sure that you couldn't be hacked, et cetera. And I did a lot of work with the Paranoids. Eventually, at the very tail end of my time there, I actually left the legal team and went over to the Paranoid team to work on one particular problem that was annoying me. And I wanted to get fixed before I went out on maternity leave. And so I worked with them constantly. I was on the company's global information security task force, where we were like the think tank that worked with the security team. So I worked with them quite a lot.
Okay, now you mentioned the Paranoids were security. Were they in charge of child safety?
Not at all.
Okay, maybe we'll come back to that. What did you do for your next 7 years, I think you said, after you left Yahoo?
Oh, well, after I left Yahoo, I stayed home with my daughter so I did a year of college in India way back in the day. And then I did a lot of work in India in connection with what I was doing at Yahoo. And I adopted a daughter from an orphanage there. And when my adoption came through, I left, worked for 2 years. She had a lot of special needs and health issues at that time. And so I stayed home with her to bond, work on health issues, et cetera. I had been teaching as an adjunct law professor at my alma mater, UC Hastings College of the Law. San Francisco is part of University of California. It has a different name now. And so I continued, I was teaching a comparative cyber law seminar there for third-year law students, and I got my daughter home, kept teaching my seminar once a week, and consulted for free with a friend of mine who had just become the GC of YouTube before the acquisition of Google.
GC, you mean general counsel?
Yeah, she was the general counsel. She asked me to come work there and head up all the functions I had at Yahoo over there, but I just brought my daughter home. I'm not the lean-in sort of person. I don't think you can do it all, and I wanted to just be home with her for a while. So I said I'd advise her, you know, if she needed help, but I wasn't going to take the job.
Okay, so what did you do next after that talk with the head lawyer at YouTube?
So I guess it was around just a little under 2 years after I got my daughter home, I got a call from someone I had worked with at Yahoo, who was the head of European legal, who was now, he had moved on to become the head of Adobe European legal. And he asked that I go down and talk with that company's general counsel and executive team, because they were planning this transition from being a company that burned software to a disk, put it in a box, mailed that box around and licensed it to people. And they wanted to make this transition to being a cloud-based, you could back up all your stuff there company, but they had a legal department full of software licensing lawyers, and they didn't have anybody who had worked on any of the sorts of things that come along with being a cloud company. Once you're storing your customers' data, once they're allowed to back up their data to your cloud, you have law enforcement functions you need to build out. You've got trust and safety program you need to build out. And you have a massive amount of infrastructure that you need to build out that lives behind that, you know, people oftentimes don't think about, because that function is invisible, you know, it's deliberately invisible to the end users of the platform. But people that haven't worked in that area before might not know the full extent of what they have to build if they want to move into that space.
Okay, so how long were you at Adobe?
Well, I was at Adobe. I started off as a consultant. They brought me in as a consultant for 4 months, I guess it was, to help them get their brain around what their obligations would be. And then at the end of the 4 months, they asked if I would stay on and run that. So.
And how long did you do that for?
I was there for 11 years.
11, okay. While you were at Adobe, or when you started there and you came there, did you observe any of the same risks and problems that you had seen at Yahoo?
when I first got there, yes, I knew that. So the product that we ended up launching eventually was called Adobe Creative Cloud, and it's their main flagship product now. I mean, everybody knows Photoshop, right? I mean, Photoshop, Lightroom, InDesign, Illustrator, all of Adobe's software for creative professionals bundled into a subscription offering, not a license that you just get. And people subscribe monthly. They download their software from up in the sky and they can back up all their content there. So,
And so what kind of risks did that show?
well, so if you can back up, I mean, Photoshop, global software, that means if you're going to be backing up their content to your cloud, you've got the photography, the videography of every professional photographer in the world on your cloud. And chances are, I mean, the reality is anywhere on any platform that you can upload and store photos and then share them, you're going to have CSAM.
Okay. Was your job at Adobe purely legal, or were you doing other things beyond that?
No, I mean, there were legal aspects to my job, but my primary role was building out this trust and safety function from zero, advising the product teams what they would need to do, working with engineers, and ultimately I had my own dedicated engineering team, working with my engineering team to build out that backend infrastructure that we needed, and then eventually launching a photo DNA program to proactively scan for CSAM on upload so that we knew I didn't want to end up again ever in my life in the situation that Yahoo ended up in with Candyman, where by the time you get the search warrant, this has been going on forever. So,
Yeah, I'm sorry, what was Candyman? Was that was the big bust you talked about?
well, yeah, and let's go back to that just for a minute because I realized I left something out. So when I was at Yahoo, after Candyman happened, we were all horrified. I mean, there's something about having to view, my team and I had to bundle up all that content for law enforcement. There weren't good tools at that point for one-click bundle everything. So it meant we had to see it all. And I mean, I remember somebody on my team coming in, we had a deal between us. I hated seeing the blood and gore and he hated seeing the sex stuff generally. And so he said, and he came in and he was such a stoic guy and completely in tears. And he's like, I can't do this one. I can't do this one. And so I said, okay, I'll cover. And then I saw what he was talking about because, there were so many sections devoted to prepubescent and younger kids. So once we got through that crisis, the company led by our domestic team, Elizabeth Manker and Emily Hancock, worked, and then I helped where I could. We worked with NCMEC, we brainstormed with our own engineers, we worked with NCMEC, we worked with imaging researchers, because we wanted to figure out how do we get ahead of this. And so there we launched what was then called, we just sort of informally called it the Hash Project, where NCMEC would feed us a pool of hashes. Has the jury learned what hashes are? Should I explain it?
Sure.
A hash is just a numeric representation of an image. And so with a simple hash value, back then we were using just simple MD5s, you can take an image and convert it into a numeric string. And so if somebody uploads that exact same image, you can detect it and take it down.
Mm-hmm.
So I think it was 2004, we launched the Hash Value Project, and we had a lot of success with it.
That was at Yahoo.
That was at Yahoo.
Okay.
We had a lot of success with it at Yahoo, but other providers didn't. The reason why we had success with it at Yahoo, an MD5 hash isn't very robust. If you change a single pixel in the image, it's going to have a different numeric string. And so, CSAM, sometimes it's a copy of a copy of a copy. It might be bigger, smaller, whatever. You're going to miss those copies of copies with just a simple hash. So we were having luck catching exact copies of copies. Microsoft was not because they compressed their images,
Hmm.
so they weren't able to match, right? So it was from that first hash value project that Microsoft went back to the drawing table and said, we got to figure out a solution to this. And that's kind of how PhotoDNA came about, was out of that
And we
first.
will talk about photo DNA.
Yeah, approach.
Yes, ma'am.
Okay. Ms. Worth, I'd like to go back to DDX 19.2 and put that on the screen, which we've looked at previously.
Yes.
And over the course of your career, from Yahoo to Adobe to your consulting, have you had the opportunity to work with employees of other major tech companies on
Yes, I
trust and
have.
safety? Okay, can you describe that?
Well, so again, out of that original hash value project, which was Yahoo, Microsoft, I think AOL was part of it as well. Eventually, that grew up into what's known as Technology Coalition. And Technology Coalition is a nonprofit collaboration between technology companies that have anti-CSAM programs or companies that have the type of service where that may become an issue for them in the future and they want to learn about it.
Yeah, and that I see that. There's some other organizations on here. One of them is NCMEC. Have you worked with them?
I've worked very frequently with NCMEC.
Okay. What is Thorn?
Oh, Thorn is a nonprofit that was launched by Demi Moore and Ashton Kutcher, and it, with an intent of wiping out CSAM on the internet. I was asked at some point to become a member of their industry advisory board and work with Thorn on that. It was funny because I remember going to that meeting kind of cynical with rolled eyes, like, okay, great, another celebrity vanity project about rescuing children that's not going to do anything. And I was never so happy to be completely wrong. I mean, they had great ideas, terrific people, and they really did a lot of great work developing technology that smaller companies that didn't have the resources to build an anti-CSAM program to help them launch more easily. So,
Got it. And there's also a reference here, you mentioned this, to the Dallas Crimes Against Children Conference.
yes.
What is that?
So the Dallas Crimes Against Children Conference is really the world's largest global conference on preventing crimes against children, including CSAM. It takes place in Dallas, Texas, every August. Unfortunately for me, it's always the second week of August, and so it always landed on my birthday. So I always got to spend my birthdays in August in Dallas heat, talking about CSAM. And so the Crimes Against Children Conference, I mean, it's everybody that works on this problem. It's ICAC investigators, Homeland Security investigators, it's social workers that work with the victims, it's the technology companies, it's everybody.
Okay. Now, what year did you leave Adobe?
I left Adobe, I think spring of 2019.
Okay. And since leaving Adobe, what have you done for work?
So I left Adobe thinking I would take a year-long break. My daughter was transitioning to high school. She was going to be she was the only freshman to make her high school sailing team. And she was going to be traveling every weekend with the rest of the varsity sailing team, who were all 17-year-old boys. And so mom was going to chaperone every one of those. And so I figured I'd take a year-long break and then figure out what to do next. And then, of course, the pandemic slammed down and I had a daughter going to high school from her bedroom.
Okay. So then did you end up doing any consulting for clients?
So yes, I did. And it came about, I wasn't looking for consulting work. Frankly, I didn't want to work for a little while after so many years of working on very difficult subject matter. But I got a call fairly early on. I think it wasn't long after I left Adobe, from a former colleague who had left Adobe and gone to another company. And they were contemplating introducing to that company a whole variety of user-generated content features and social network-like features. I mean, the company, they actually said it was okay for me to use their name, but because they didn't have a CSAM problem, they were trying to make sure they got in front of all sorts of problems, but it was Ancestry. So I don't know how many of you have ever used Ancestry, but previously, well, they were working to become more social, so you could upload photos consistent with, with your family tree, share them with people that you might be connected with, have direct messages back and forth, so that you could comment on people's photos, things to that effect. And so they asked me to come in and advise their executive team on what they needed to build out, given what they were planning as a business.
Okay. Now, in the past 7 years since you've been at Adobe, have you kept up with the latest literature and issues that are relating to child safety and CSAM in particular?
Yes, I have. I mean, you have to.
Okay. Have you been recognized in the industry for your anti-CSAM work?
Nobody in trust and safety gets recognized. It's a very thankless job because when everything is going right and working, everybody just thinks that's just normal, right? They don't see everything that's going on behind the scenes to make it normal. And then one thing goes wrong and we're called out in the press, et cetera, et cetera. But I mean, I don't need accolades or anything like that. I mean, I've been recognized by my peers in ways that matter to me, so.
Okay. Are you an expert in mental health or offering any opinions today to the jury about mental health?
No.
Are you an expert in addiction or offering any opinions to the jury about addiction?
No.
Same question. Are you an expert on suicide and self-injury or offering any opinions on suicide and self-injury?
No.
Are you an expert on eating disorders and offering any opinions on eating disorders to the jury?
I mean, I know about all of these things through the course of my trust and safety work, but I am not an expert in them.
Okay. And just to get ahead of this, Ms. Worth, you're being paid for your time today, is that right?
Yes, I am.
Okay. What is your hourly rate?
My hourly rate's $1,000 an hour.
Okay. Is that the same rate that you charge for any for-profit?
No. So I charge, that's my standard rate.
Yeah.
For a small company, I might half it.
Mhm.
For VC firms, I raise it by about 50%. And for nonprofits, I don't charge at all. So
Okay.
It all works out in the wash.
How does your compensation for serving as expert in this case relate to your overall income?
I mean, it's very good compensation, obviously, but I mean, I'm very fortunate to, especially as somebody that grew up like in a family of broke artists and musicians. I was very lucky to be at 2 companies that paid me partially in stock, and invested a lot of that in real estate. And so most of my income comes from that.
Okay. Ms. Worth, we talked about what you're not here to opine on. What subject matter generally are you here to offer opinions about for the jury?
I am here to offer an opinion on best practices in developing and operating an anti-CSAM program. I am here to offer opinions on trust and safety programs generally. I am here to offer my opinions on age gating and age assurance practices.
Mhm.
in the industry.
Okay. Your Honor, at this time, Meta offers Ms. Worth as an expert in trust and safety, including child safety and anti-CSAM programs.
Any objection?
No objection, Your Honor.
All right, she's admitted.
Okay. Let's dive in. Ms. Worth, if we could please look at DDX 19.5, which is one of the slides you prepared.
Sure.
Is this a roadmap of your testimony?
Yes.
Okay. What do you plan to cover first?
Well, at first I wanted to put this problem a little bit in context, right? I mean, we've been talking, I was here watching some of the openings, et cetera. We've been talking a lot about Meta's practices, but I wanted to back out a little bit and talk about the problem overall. I wanted to walk the jury through my evaluation of Meta's CSAM program based upon the methodology I've used at the companies I've worked at.
That's the second topic?
Yes,
Okay.
and that I've used since then and improved since then working with others.
What's your third opinion about? What's your third opinion?
I was going to offer my opinion. I was hired in part to rebut Dr. Levine's testimony, his expert report, and I'm just going to give my evaluation of Mr. Bahar's report because it goes to some of the things that...
Objection, Your Honor. This misstates testimony.
Ms. Worth, I believe you said Mr. Bahar's report. Did you mean his testimony?
Yeah, so
And Your Honor,
in my...
Just one moment, please.
Your
Okay.
Honor, the state restates its objection to the Bahar point as an undisclosed opinion.
And Your Honor, we covered this yesterday, and I think as we see how the testimony develops, I understand that there's an objection to Ms. Worth talking about Mr. Bahar, and I think we'll see how that develops.
All right, so at this point, I'll file that away, but thank you for reminding me of it.
So Ms. Worth, let's come back to that one.
Okay.
We'll come back to number 3. We'll get there. What's the fourth opinion that you're going to talk about in the roadmap?
My evaluation of Meta's age assurance systems.
Okay. And what do you, at a high level, intend to opine about those age assurance systems at Meta?
Meta's age assurance systems are standard in the industry, fully in line with best practices in the industry as put forth in the Digital Trust and Safety Association's, best practices for age assurance systems, and fully consistent with guidance that is given in very plain languages to business by the FTC on its FAQ page.
Okay, we'll come to that. What is the final opinion, number 5, that you plan to offer to the jury?
I plan to offer my opinion about Meta's transparency and its child safety risks.
And at a high level, what's your opinion about that?
Meta, at so many steps in the process, is very clear to users that its content moderation programs are not perfect, that it will miss content. It is very clear that while it has anti-CSAM programs and teen safety features, they are not perfect. And that is not unique to Meta. Trust and safety programs are about harm reduction, not harm elimination. Sort of in the same way, over the course of my lifetime, we've gone from seatbelts to airbags. Safety's improved, like safety mitigation features, safety harm reduction features in cars have improved exponentially. Things still go wrong, right? Things happen. And that is the same thing in trust and safety. We do our best to develop layered systems that come at a problem from multiple directions to try to reduce harm as much as possible. But harm elimination, we'd all love if we could achieve it, but it isn't realistic.
Okay, let's start at the beginning with the first opinion. Ms. Worth, have you been following the presentation of some of the evidence in this trial?
Here and there, I haven't been able to follow it fully.
You mentioned the openings.
I got to watch the opening statements and I read the testimony of Brian Levine and a few others.
Okay. Did you follow the testimony of Arturo Bahar?
I did. I watched the testimony of Arturo Bahar.
Come back to that. We have heard a lot about child sexual abuse online, as you know. As an expert in this area, have you reached a conclusion on how big picture society should respond to the challenge of online child sexual abuse?
Well, I mean, yes, I have. And I think this is where we're supposed to move to 19.7.
Sure, we can go to the next slide.
So backing up big picture, child sexual abuse is a tragically common problem worldwide, offline and online, and it predates the internet. It certainly predates Meta, and I can say that personally because when I was working on the Candyman case that we were talking about earlier, Mark Zuckerberg was still in high school. That just made me feel really old right now. So Mark Zuckerberg was still in high school. We were buried in Candyman material and struggling to figure out what it was we could do about it. Also, while technology companies can and do try to get in front of all of these sorts of problems, everybody has a role to play. This is a joint collaboration, and this is something out of the exhibit that's up here right now. Is this displayed? Yeah. I like the way the Department of Justice put it in a report that it put out not that long ago, 2023, that the Justice Department couldn't combat child sexual exploitation alone. It's an ongoing public health crisis. It requires a whole of society strategic response. It requires action by Congress, online service providers, non-governmental organizations, that's like NCMEC, and foreign partners, and by parents and caregivers as well.
And so,
Service providers do their part, but we need help from everybody else too.
and to be clear, your opinion is that service providers like Meta, Yahoo do have a role as well in addressing this problem.
Absolutely, we have a role as well, but we partner with, for example, parents and teachers. That's why we put out educational material and family centers on site so that parents can be well educated about how to best protect their kids, while we can take down CSAM and report it to NCMEC, we count on NCMEC referring that out to law enforcement. When we file a cyber tip, we're obligated to preserve the entirety of the account contents and store them in anticipation of receiving a search warrant. We count on law enforcement following up on that cyber tip, getting a search warrant, and getting that data, right? We need them to do their part.
So-
we don't have authority to arrest these people or take action.
So if we go to the next slide, 19.8, my question is, do you have support for that conclusion from other major international organizations?
Absolutely. So, and this slide, it's quotes from a variety of different organizations and studies, but this is offline data. Offline, just in the real world, 1 in 5 women, 1 in 7 men globally report being sexually abused during childhood. This rate rises to 1 in 5 when we're talking about non-contact sexual violence. It's a global challenge, offline and online. And you might want to go to the next slide.
Sure, we can go to the next slide, 19.9, if you like. What does this show?
Well, and this is the other thing that I wanted to emphasize. Only about 16% of real world child sexual abuse cases come to the attention of the authorities. And I think we understand as a society that police aren't going to solve all these cases. So in the US, police only clear around 26 of sexual assault or rape cases. And it's considered success if you get higher than that. So out in the real world, when these things are happening, law enforcement solves the problem about 26% of the time, according to studies. Nobody's expecting perfection, right? And we understand that police can't clear all
Your Honor, may I approach?
cases in the real world.
Yes, you may.
Let the witness answer. And can we take down this slide while I approach?
Okay, Ms. Worth, sorry about that. I just want to ask a clarifying question. Are you here to assign, can we please put that back on the screen, Jeff? Oh, sorry, Your Honor. Permission to publish that.
Yes.
Ms. Worth, are you here to assign blame to the New Mexico Attorney General or to social media? Is that part of your opinion set?
My role here is to make sure, to give information to the jury that helps them understand the big picture and then practices within the industry.
Okay. While we're here, I want to talk just about some terminology. We've heard the term prevalence a lot in relation to
Yes.
Meta's platforms. Can you just remind the jury, please, what prevalence means in this context?
Okay, so prevalence is a concept where on a platform you evaluate how common a particular type of abuse is and every company does it slightly differently. At Meta, I believe the way that they look at it is how many pieces of offending, how many times is somebody going to see offending content per 100,000 views or something to that effect, right? So it's how often does this problem occur on your network despite your best efforts?
Okay. I want to come to that in a moment. I think that you talked through a couple of these boxes that we're looking at. The final box, what does that mean, a backlog?
Well,
Generally, a backlog, what does that mean?
yeah, so in terms of backlog, I mean, I said earlier that it's a whole of society problem. Everybody needs to pull their weight, right? We count on law enforcement following up on the cyber tips we file. Every single cyber tip, and it's the law, that providers have to bundle up the entirety of that account before they delete it. And not just the CSAM, because other data within that account might help you identify, help law enforcement identify who the offender is. So we wrap up IP logs, we wrap up all their email, we wrap up everything, we set it aside and we wait for the search warrant. But, in New Mexico, data that's been produced in this case, evidence produced in this case, shows that New Mexico has a backlog of, over 1,000 cyber tips. And if my recollection is correct, I think they follow up on about 5% of the ones that Meta submits.
Okay. Now I want to go to Meta's numbers now. So if we could please go to the next slide, it's 19.10. And what is depicted on this slide, if you could help the jury?
Oh, I mean, this is just, again, big picture for Meta. Running any trust and safety program is extraordinarily challenging. Doing it at Meta scale, I mean, they have 3.3 billion daily active registered users as of last year, the end of last year. The world population is 8 billion. It's like half, you're policing half of humanity. So law enforcement working in their community can clear about 24% of sexual abuse cases. Meta is policing half the world. So really just keeping that scale in mind, I think, is important as we go through each of these areas, because even if you're doing an extraordinary job and say you're getting down 98% of the problem content, when you're talking about the scale of 3.3 billion people uploading photos and comments and talking to one another every day, it's still a lot of content, right? So this is just, again, big picture, scale.
Okay. If we could please go to the next slide that you prepared, which is 19.11. And you've mentioned your time at Yahoo, and you keep mentioning this term Candyman. And on slide 11, I'm just hoping that you can tell us what this is, and again, just what is Operation Candyman?
Okay, so we talked about this a bit, and so I'll keep it fairly short.
Mm-hmm.
So when the Candyman case happened, we didn't have anything like photo DNA. And Candyman, what law enforcement did, and it made total sense, there were a lot of members of the group, but because child predators often put themselves in positions of trust with children, camp counselors, priests, babysitters, all sorts of things. Law enforcement focused in this case, their sting in this case, on those people within the Candyman group that they could identify that were in positions of trust. In this case, this was actually a really great Wired article that happened, that came out about 6 months after the bust happened, about this one particular police officer and Marine who was a local hero to everybody getting caught up in the scandal. So
what did you personally do in relationship to the FBI Operation Candyman and the response?
well, so the FBI operation was not my jurisdiction. That was, our team was split, as I think I said before, between domestic law enforcement response and international. So the domestic team handled everything that came from the Justice Department. When you are dealing with foreign law enforcement, it takes them longer to get processed to you because they have to go through a really cumbersome process called the Mutual Lateral Assistance Treaty process. So my team then got the second wave of process coming in after the first Justice Department wave hit. So of requests from law enforcement.
Okay. And we're still talking about the sort of broader societal context of this problem. What was Yahoo's response while you were there to this bust?
Well, it was devastating to everybody at the company. It was, and it was particularly now that there are much more mature anti-CSAM programs. There are things like wellness protections that are part of the program, et cetera, that protect people by slightly blurring screens or doing all sorts of things to lessen the impact of what you're seeing on yourself psychologically. We really didn't have any of that.
And you mentioned the Hash project came out of this?
Yes, the Hash project came out of this, and ultimately Technology Coalition.
So in a terms for a layperson like me, because there are a lot of, you said MD5, Hash, what is the Hash project and was it successful?
Well, I think I explained that it was simple hashes, MD5s, that are not particularly robust, and changing a single pixel changes whether your program is going to catch it. And so since Microsoft compressed their images and Hash project wouldn't work for them, that's why they went back to the drawing table with a really terrific imaging researcher by the name of Hani Farid, who came out of Dartmouth. And even working very, very hard on it. If you consider that we launched Hash Value Project in 2024 in partnership with NCMEC, I think Microsoft announced PhotoDNA in 2009.
Did you mean 2004 for the Hash Value project?
Yes.
Okay. And then in 2009, something comes along called PhotoDNA?
Yes.
Okay, if we could look at slide 19.12. What is this slide? And we've heard it a few times at trial, but what is PhotoDNA?
So I really love the way, I'm kind of a nerd, I love the way PhotoDNA works. When they went back to the drawing table, they were trying to come up with a way to make more robust, more precise hashes that could detect that it was the same image, whether it was black and white or color, whether it was larger, smaller, grainier. And ultimately what they came up with was a completely different type of hash where I can't remember the exact number. I think they separate every image into 26 component squares. They analyze the patterns of light and dark within each of those squares, and then use those patterns of light and dark to come up with their hash. And that way the hash is more robust. It's going to catch the same image in a wider variety of contexts. So
what is this slide, these 5 images, what does this depict?
The process, I guess, that I just described. This is just straight off Microsoft's website when they're explaining how PhotoDNA technology works. And I just gave the thumbnail version of that.
Okay. Now, Microsoft developed PhotoDNA?
Well, Microsoft built PhotoDNA, and they were the first ones to use it. And then eventually they made it available to other service providers under a limited license. You could use it exclusively to proactively detect CSAM but you couldn't use it for any other purpose.
Okay, what was kind of the history of other platforms adopting this photo DNA tool?
So they made it available, but I need to really emphasize, they made it available as a protocol. It wasn't something that you just plugged in and then it worked, right? So building out a photo DNA program, I mean, I can tell you from personal experience, it's hard. You need engineering resources, you need, lots and lots and lots of engineering resources. You need to plug what you build into all of your different products. Adobe, we had, I mean, I think at least 60 products that involved and apps that involve photo upload, storage, and sharing. So you need to find places where this is going to live. You need to build out the tools that are going to let you, look at the images, disable the users, bundle the content the way that you're required to bundle it when you file a cyber tip so that law enforcement can come back and get it. So it's a really massive, extraordinary effort.
What was the first social media company to adopt photo DNA?
Well, Microsoft says it was Facebook, that Facebook adopted it around I think it was 2011.
What is the state of photo DNA's broader industry adoption today, and how did that come about?
Well, I mean, Technology Coalition, we can't pull up the webpage, but there are quite a lot of service providers, internet service providers that use it, and then a few very large ones that don't.
Okay. Does Meta still use it today, or did they stop using it?
Meta still uses it today, I believe, but they also have developed their own proprietary version of something that's akin to photo DNA that they use themselves.
Okay. Did anyone, was it Microsoft sort of evangelizing photo DNA, or were they just offering it for use?
Microsoft was evangelizing it once Meta was on board. Meta was evangelizing it, trying to get, I mean, the problem is that once one service provider adopts it, then everybody moves over to the next platform that isn't using it, right? And the bad guys in this space, child predators, they are extraordinarily persistent. And I think maybe one of the most difficult things about working in this area, aside from seeing the imagery, is that it's a constant game of whack-a-mole, that you come up with a way to stop these guys. It's working for a while. They figure out an end run around it. And then you've got to adapt what you've done. It's a never-ending whack-a-mole.
Okay. Now, you mentioned a couple big companies that do not use this photo DNA technology. I don't want you to name them, but why does it matter that some companies use it and some don't? Some need to be encouraged, some don't.
Well, so just to back up, NCMEC is very clear, and it puts it on the front page. Every year, NCMEC files a cyber tip by ISP report that they publish to the world, and it lists page after page after page of who filed cyber tips and at what volume, right?
And let me actually stop you there. You mentioned NCMEC, and I know this is one of your pet things. Did you prepare a demonstrative that's a physical demonstrative?
Oh, I did.
I'm going to flip that around, and you can tell me if this is
okay.
the demonstrative you prepared. I also have an affinity for big poster boards.
Oh, there we go.
Okay.
I can't see it. That's way too far for me.
Bring it closer.
Okay.
Can you see it?
Not really, but I kind of know what it says, so.
I'm really great at this. Let me do this. I'll put one here.
And maybe put one closer to me, right? I don't know.
Okay. I know you wanted to prepare this. And so, I don't know what this is. What's the demonstrative that you wanted to
Can they see it, or?
I think they can see.
Or am I just describing it? Oh, you've got one over there. Okay, great. So every year, this is the 2022, the front page of the 2022 report. NCMEC publishes this cyber tip by ESP report. And they say something very critical on the front of it that I think is extraordinarily important to understanding the big picture here. And it's extraordinarily important to the opinion that I gave in my expert witness report. So they say, and they vary this every year, US-based ESPs are legally required to report instances of apparent child pornography to the cyber tip line when they become aware of them. But there are no legal requirements for proactive efforts to detect this content. Higher numbers may indicate robust efforts to identify and remove abusive content. And I think in other versions of this report, they've said not necessarily higher amounts of CSAM, right? So NCMEC is very clear, and this is the non-governmental organization that's tasked with receiving cyber tips and then reporting them out to the appropriate ICAC squads around the country. You have a legal obligation to report when you become aware. So some companies just wait till they become aware, till someone reports CSAM to them. You've got no obligation to proactively look for this stuff. And so some companies choose just to stay a black box. You know, they don't scan, they don't search, they don't look, because if you don't know, you don't know, right?
And how does that relate to the photo DNA slide that we were looking at a couple minutes ago?
Well, how it relates to the photo DNA slide is, I mean, photo DNA is what you use to look. So, you know, companies that are voluntarily proactively looking, and you'll hear me talk about proactive and reactive a lot. So by proactive, I mean, you're going out and trying to find it yourself. You're not just sitting back and waiting for someone to tell you about it. Meta goes out, proactively looks for CSAM in a variety of ways, through hash values, through classifiers, through heuristics, a whole variety of different ways. And I mean, they file more cyber tips every year with NCMEC than every other service provider combined. I think that's for at least the last 5 years.
Does that, let me jump in there, and
Yeah.
this might be the last question before good time for a break. Does that mean that Meta has the biggest problem, or that it's the biggest problem in this space because it's reporting the most?
No, it does not. And you know what I found really, so like NCMEC says, high reporting numbers may just mean you look harder, right? It doesn't mean you have more CSAM. The people that are scanning using photo DNA are finding it, right? Companies that don't scan, and I'm going to name one, Apple, right? I mean, just to be very clear, I don't have my phone with me, but these days, the vast majority of CSAM that's created is created with that phone, that device that everybody has in their pocket, right? Apple has the largest market share of that. People back that up to iCloud. Does anybody search, do they search iCloud? They do not, right? So you can upload CSAM to iCloud, they don't know. You can share it via Apple Messenger, that, I don't know how many of you have Apple phones, they won't know because that's end-to-end encrypted. Apple Meta files millions of cyber tips a year. On average, Apple reports about 250.
Okay,
The largest smartphone manufacturer in the world.
and we'll come back to that. Your Honor, now that I've sufficiently embarrassed myself and my arm is getting tired, I think this would be a great time for a break.
All right, thank you for the alert to the natural breaking point. Ladies and gentlemen, we'll take a morning recess and we'll call you back in shortly.
All rise for the jury.
thank you for your attention this morning. Hope you had a good break. And with that, we'll get back underway. Council, whenever you're ready.
Thank you, Your Honor. Welcome back, Ms. Worth. If we could please pull up slide 19.3 from your demonstratives, I'd like to get started on your second opinion for the jury.
19, oh, yeah, okay. 1913.
Now, Ms. Worth, when it says here on the slide, anti-CSAM program, what type of content or behavior overall is included in that?
Okay, so in an anti-CSAM program, you're not just, I mean, some CSAM programs might just be looking for child sexual abuse material. Meta's anti-CSAM program is looking for not just CSAM, but any content that is exploitive of children. So child exploitive imagery, sexual grooming, adults trying to groom children, sextortion, anything within those sorts of categories. So it's broader than just CSAM.
Okay, and Ms. Worth, do you have a framework for evaluating a company's anti-CSAM programs?
Yes, I do.
And just how did you develop that framework?
Well, so when I went to Adobe to build out their trust and safety program, there was no real industry organization on trust and safety yet that you could look to for benchmarking, best practices, you know, what is the entire industry doing and what can we learn from that? And based on the size of our company, what should we build? And so I went, having been at Yahoo was a real advantage because everybody that was at Yahoo left to go head trust and safety or other programs at companies all around Silicon Valley. So I spent a fair amount of time picking up the phone, calling friends. Hey, Kathy, my friend at Google, I need to find out how you guys are managing this issue. Is there anybody at your company that you think would be willing to talk to me? Okay, great. And then I would talk to them. Might go down and visit them in person and do that over and over and over again so that I've been out of the game for 2 years. We weren't quite to where photo DNA was widespread yet. And I wanted to understand what everybody in the industry was doing. And then,
So if we go to slide 19.14, actually,
yes.
can you tell us what this is?
Yes, so this is sort of the top level headlines of my framework. And it's rooted in, I mean, it's evolved over time. So I think I first started doing this roughly around, I mean, I'm ballparking at 2011, 2012. And then as we became members of Technology Coalition, then you're having Technology Coalition meetings, you're going together to Dallas Crimes Against Children Conference. You have lots of opportunities to talk with everybody else in the industry that's running an anti-CSAM program and find out what they're doing.
So Ms. Worth, we're going to get into each of these 5 points, but at a high level, do you view it as important to have a methodology, a framework, before you evaluate an anti-CSAM program?
Well, you have to have a methodology. Otherwise, you know, a methodology is, you know, your plan for reviewing the program where you ask, you know, what's the standard? How are they doing? You know, are they up to standard in this area? And according to who? According to what objective benchmark? If you don't have a methodology and you don't have a plan, then it's just an opinion.
Okay, I want to ask you about that in the form of a contrast. Did you review Dr. Levine's expert report in this case?
I did.
And did you review the documents that Dr. Levine cited in his report and discussed in his testimony?
Yes, I did.
And what did you do to sort of follow up on the concerns that Dr. Levine in those documents raised, if anything?
Well, I mean, I did a lot. I mean, I've spent so much time reading documents and depositions in this case, but one thing that I found consistently throughout Dr. Levine's report is that he would cite something as a concern in a certain line of a document, but not read the next page that gave you the context you needed to understand how that related to what was actually going on. Or he didn't go and read the deposition of the Meta executive that testified to give that context. So that's reading everything, scrolling through every page of the email, reading the related deposition testimony. That's what I did.
So as an expert in the field of online trust and safety who's using this framework with other clients that you consult for, how do you personally avoid cherry pick when you're doing your work?
Well, how you avoid cherry picking is you're very clear with the client. I need to see everything, good and bad, that relates to each of these categories that I'm evaluating for you. Anything you have, good or bad, I need to see it. And clients don't have a problem with that generally because they know it doesn't do them any good. Why get an opinion from you that's skewed? You need to see the good and bad to come to a conclusion.
Now, to be very candid, did Meta only show you the good or did Meta show you some good and some bad when you were doing your work here?
Oh, I saw a lot of bad.
We're going to talk about that.
Yeah.
One thing I want to do though first is number one on your framework, it says safety by design.
Yes.
I think that's something that we heard Dr. Levine talk about. What does safety by design mean?
So safety by design wasn't always called that. It's a process that's existed for a long time in trust and safety, before it was called trust and safety. It's really the process, when I was at Yahoo, when a product was going to go out the door, that product team has a checklist. Did you get security sign off on your product? Did you get, this other group to sign off on the product? Did you get trust and safety to sign off on your product? And by trust and safety sign off, that meant me or somebody on my team sat down with them, went through how their product worked, said, oh, wow, you have this feature. That feature can be abused for CSAM. That feature can be abused in this other way. And then you try to bake in mitigating technology or plug them into pre-existing systems designed to stop those harms before they went out the door.
What did you think of Dr. Levine's version of safety by design?
Well, what was funny to me about that, he didn't talk about it as much in his written report, but he did on the stand where he said,